His email said, "Hey folks on Twitter, wanted to flag the below tweet. I'm wondering if we can get moving on the process of having it removed ASAP. It makes me so sick. Our own government, Clark Humphrey, disgusting person. Dude, they don't work for you. We're gonna sue you, Zuckerberg, if there's misinformation on your platforms." Kate Bedingfield from Biden and Harris's White House team. These people are sick. Do you remember all this? Just makes your blood boil. Takes you all the way back to COVID insanity. People die from not being properly informed all the time, right? It's a problem. That's why there's warning signs everywhere. Warning, don't do this thing. If you do, it's going to be a problem for you. RFK Jr. with a victory as he fights Biden's censorship efforts. You can see this one just came out of West District of Louisiana, the Monroe Division. It's a ruling back down from the Fifth Circuit. It involves Robert F. Kennedy suing Joseph Biden, all related to censorship. So let's unpack what's happening here. Now that Robert F. Kennedy has endorsed President Trump and committed himself to making America healthy again, let's see what he's been fighting for in one of his many lawfare battles. They say here, back on February 14th, this court issued an injunction in favor of RFK and the Children's Health Funds and more against the White House, FBI, CDC, and many others. The government then appealed this, and it was consolidated with Missouri versus Biden, the censorship case. Now, the parties in this case and the Missouri case overlap considerably. We remember the Missouri case. Now, in fact, the court's preliminary injunction in Missouri was against some of the same people here. That injunction was narrowed, and now it's been limited. Then we got the case back on July 25th, and now we're talking about standing. On August 1st, Kennedy filed a supplemental brief on standing, saying we have a right to be here, and then the government responded saying, no, you don't. Kennedy, you have to go bye-bye. So Kennedy wins this one. Let's see how this happened. So they say, all right, Article 3 of the Constitution limits federal courts to cases and controversies. You got to actually have a case. You got to actually have a controversy. If there is no actual complaint or something to resolve, you can't come into this court. The law of Article 3 standing was built on separation of powers principles. We resolve these claims. Standing has three elements: an injury in fact, actually injured, it's traceable to the conduct of the defendant, and it's redressable. Bing, bang, boom. 1, 2, 3. Now here, Kennedy is invoking federal jurisdiction, and we're talking about the merits, gives us some background on the Supreme Court, but here we're talking about standing. Now, the purpose of this ruling here today is to determine whether Kennedy and these other entities have standing. So we got to ask ourselves why the Supreme Court found that in Murphy, these plaintiffs did not have standing. It held that the plaintiffs must demonstrate a substantial risk that in the near future, they will suffer the harm again. Now, because nobody was going to prove that they could be harmed again, there was no standing. In that case, the Supreme Court focused on the fact that they were making direct censorship injuries, and so they had a problem with causation there. Now, in this case, we have different plaintiffs: RFK Jr., Children's Health, and others. Now, each will be evaluated separately to determine whether they have standing here. Now, at the outset, this court notes that where the alleged government coercion has come from numerous people at numerous agencies, it's almost impossible for most plaintiffs to prove standing without discovery, saying you guys all censored us. Much of the alleged pressure that's asserted by the Kennedy plaintiffs were private meetings, private conversations, and so we need some discovery. Now, the government says that no, Kennedy has waived their right to claim direct censorship. They can't claim that we were censored because this is a class action. However, in making the claim, the Kennedy plaintiffs also alleged that they were victims of direct censorship. So there was a class action claim and there was direct censorship. And so there's no waiver. So here is how standing applies to RFK Jr. They say this court finds that RFK Jr. in this lawsuit is likely to succeed on his claim that suppression of content that was posted was caused by government defendants. Yep. And that there is a substantial risk that this is going to happen again. Okay. Kennedy posted stuff. They censored him. It's likely to happen again. Boom. He's got standing. They say most of the evidence in the other Missouri case, which was the other censorship case, it relates to actions by government defendants to suppress content related to COVID and the 2020 election. Kennedy, along with his other nonprofit, were in positions contrary to government positions on COVID. They had different opinions on masks, on the mandates, on the injuries, on the lockdowns. And Kennedy, who's currently running as a presidential candidate at the time this was written, was identified as a member of the so-called Disinformation Dozen, 12 individuals the government specifically targeted. The Disinformation Dozen was initially identified by the Nonprofit Center. Yeah, they always say, oh, nonprofit. That means what, nonpartisan? No, extremely partisan. We just have a nonprofit label for tax purposes. Center for Countering Digital hate in March 2021. Center for Countering Digital Hate. RFK Jr. telling you about some things to be cautious about is countering digital hate. He was identified as part of the disinformation dozen because he was an anti-jabber. Now, 3 days after Biden took office on January 23rd, Humphrey, the digital director for the White House COVID team, emailed Twitter and asked that he be removed. His email said, "Hey folks on Twitter, wanted to flag the below tweet. I'm wondering if we can get moving on the process of having it removed ASAP. It makes me so sick. Our own government, Clark Humphrey, disgusting person. Dude, they don't work for you at X." A copy of the email was also sent by Humphrey to Rob Flaherty, that White House diva, then assistant to the President Biden and director of digital strategy. Twitter responded back to him and said, "Hey, thanks. We recently escalated this because it's so offensive and illegal. We can't take it." In February, Flaherty began sending emails to Facebook to remove, quote, dubious but not provably false claims about COVID. Facebook responded. They said, "Well, vaccine skeptical content doesn't violate our policies, but even though it did not violate their policies, they agreed to add warning labels because the White House was breathing down their neck." Facebook further told Flaherty that despite the content not violating our policies, Facebook would censor it in other ways, by preventing and discouraging posts from going viral, by using informational labels, by stopping recommendations for groups, and stop pushing content that discourages the jab. On March 1st, Flaherty and Humphrey participated in a meeting with Twitter about misinformation. After the meeting, Twitter representative Todd O'Boyle emailed, this is the judge writing, 3 White House officials to assure the White House that Twitter would increase censorship of misleading information, censoring all of us because of the government. Flaherty from the White House, from Biden-Harris's team, accused Facebook of hiding the ball, right? How dare you hide the ball? We want more aggressive action on borderline content. Flaherty accused Facebook of being the top driver of vaccine hesitancy and playing a shell game with the White House. He was such a little whiner in his emails too. He sounded like just a pathetic. Now, the White House continued to pressure Facebook after Facebook had an in-person meeting with the White House officials. Flaherty was there. Facebook provided a report to the White House. They stated, in addition to removing the jab information, it was now focused on reducing the virality of the truth. Don't want people to know too much about what's true. On April 13th, after the temporary halt of the J&J, Flaherty asked Facebook to amplify various messages that the halt of J&J may have on jab hesitancy. They said, yeah, we'll suppress the content from Children's Health, Robert F. Kennedy's organization. Sure, we'll suppress that, no problem. Judge says on May 5th, the White House press secretary Jen Psaki also told the media that Biden favors a robust antitrust program, right? In other words, if you don't censor, we're going to come after you. We're going to bring antitrust claims against you, Facebook. On May 6th, then Flaherty said, hey, Facebook. Rob Flaherty, the White House diva, wrote, seems like your dedicated vaccine hesitancy policy isn't stopping the disinfo dozen. They're being deemed as not dedicated. So it feels like that problem likely coming over to groups as well. Then in July, they put pressure to censor more info. At a joint press conference between Psaki and Murthy, remember those two? Psaki announced that they're acting against misinformation and super spreaders. Psaki also stated that the White House asks for companies to do stuff about this. Kate Bedingfield also stated the White House would be announcing whether social media platforms are legally liable for misinfo that spreads on their platform, right? We're going to sue you, Zuckerberg, if there's misinformation on your platforms. Kate Bedingfield from Biden's and Harris's White House team. These people are sick. Do you remember all this? Just makes your blood boil. Takes you all the way back to COVID insanity. I wanted to make sure you saw the steps we took to further address the disinfo dozen, who were all proven right. Now, on August 18th, Facebook announced it took action against them. The report further indicated that Kennedy's Facebook-owned Instagram account was taken down, but his Facebook was not. There were other reports on memes, magnets, and microchips. They were coming after them. The report identified Kennedy as the actor associated with the highest number of incidents reported on the ticket. The Virality Project discussed this at length. State Department Global Engagement Center, CISA. There's not much of a dispute, says this judge. I just went through it all, that Kennedy and Children's Health were targeted by the White House, targeted by the Surgeon General, by CISA, and they were suppressed. And so that all happened, absolutely. So Kennedy needs to show that this is going to happen in the future, and he wins. And the court finds that, yeah, there is a substantial risk that this is going to happen on at least one platform in the future, right? The court is saying there's likelihood that this is going to happen again. The FBI and CISA had regular meetings with Facebook, Twitter, Google, YouTube, Microsoft, and everybody. The FBI would provide strategic unclassified interviews of overviews of things, make up Russian actors. Elvis Chan, remember him? Was primarily communicating with these people. He graduated from Naval Postgraduate School. Chan's thesis was about fighting bears and trolls. And so he was an online disinformation guy. His thesis was about foreign disinformation, but the FBI made no attempt to distinguish any of this. And this was all about election disinformation. Remember, it wasn't just about COVID and like keeping people alive. It was about the election. COVID was the cover story. Chan testified the FBI had a 50% success rate in having free speech removed. Mark Warren, chair of the Intelligence Committee, told reporters that FBI and CISA were already talking with big tech platforms. 100 days before 2020, the Election Integrity Partnership was formed. 100 days before. The Election Integrity Partnership. CISA interns came up with the ideas of working with the EIP to fill a gap that existed because of a lack of resources to monitor the elections. They engaged in switchboarding, where all these little government hacks would identify election misinformation, and they would just report those to the social media companies. And now, it resulted in primarily domestic, not foreign stuff being suppressed. Reports confirm that. Specifically, the report says the primary report spreaders of false and misleading narratives were verified blue check accounts belonging to partisan media outlets and social media influencers and political figures and Trump and his family. And all these other people too. All these misinfo people. Who could they be? Trump's kids? Charlie Kirk? James O'Keefe? Fox News? Gateway Pundit? Breitbart? Just the News? Need to work harder here so we can get on that list next time. The long fuse sought to censor misinfo and disinfo all turned out to be Republicans. The court acknowledges that the report did not mention Kennedy or Children's, but it was clear that Trump was censored by the actions of the government defendants. And that means if Trump was censored, as we know, they threw him off the internet, for crying out loud. It's not out of the realm of possibility that Kennedy, who's also running, may suffer the same fate. Now, in Kennedy, he also provided a brief, and Rasmussen also came in and testified, yeah, Kennedy still gets censored, right? So you still post his name out there. The court finds that there is a significant showing that Kennedy was directly censored in the past, and there's a substantial risk he's going to be censored in the future. There's also ample evidence on the record showing that Kennedy has been directly censored in the past. He was one of the disinfo dozen. He's satisfied the standing elements, but the analysis does not stop here. He's provided evidence that in the future this could happen again. There's a serious risk here. For example, if hypothetically the FBI saw a piece of information related to 2024 posted by Kennedy, if the FBI thought that it was more disinformation and then it reached out to CISA, who's working with the EIP, who then removed the post, Kennedy could be censored again, and they're allowed to do that right now. So there is a real risk of immediate and repeated injury. And so if Kennedy has standing, that's basically the game. This case can move forward. In conclusion, there is Article 3 standing. Great decision from Terry Doty, U.S. District Court Judge, Monroe, Louisiana, decided this month, August, on the 20th. So nice decision, and this case can move forward, which means RFK hopefully will get some discovery. We'll start to hear more about maybe some emails from the FBI defendants, CDC defendants, CISA defendants. What were they saying to try to suppress RFK and children's health and all of us? We could not participate in these conversations. I'm going to talk about people who got killed. People die from not being properly informed all the time, right? It's a problem. That's why there's warning signs everywhere. Warning, don't do this thing. If you do, it's going to be a problem for you. Good idea to have these conversations so we can be educated. But our own government suppressed this from happening, even though we've got the First Amendment. The government crapped all over it anyways. So thanks, by the way, for subscribing. If you haven't already subscribed to our channel, we'd love to have you here. We go live at this time every day. We have the best chat on the internet. We have a members only stream in the morning. Links are in the description below. We'd love to have you join us over and over and over again.